There was a concept plan in there.
In that mix.
That turned out different than what was discussed.
Yeah. Because they got the senior living instead, basically.
Randy, do you have a time or amount of time you want me to move through on this?
You're the only thing on the agenda, so take as much or as little as necessary. We have, I don't know if these folks have been through this before. We have at least one person that is going to be appointed that's not officially yet on the commission. Do you know if you had commissioner training in the past few years?
If we've had any training?
Yeah, with SOAR.
Not
Open
in the
meetings law.
past couple of years.
Been-
Before that, we had a term.
Yeah, I mean, I've done it, I looked through my notes, I've done it twice, but I couldn't figure out when the last time was, but it was a while ago.
Yeah, I would imagine that most of the people that are here are gonna be fairly new. Was Andrew the one that was gonna be gone?
Eric,
Eric. Where's everybody else's name tags?
I left them down there.
Is it,
I just
So we only
prepped.
have
training?
Yeah, I just prepped who was coming.
Just get the,
Okay.
the baseline out there so folks know kind of the rules.
Jim is not gonna be gone. Okay.
Do I say that Jason is absent then on roll
Yeah,
call?
it's not just, do I like it or don't I, it's actual rules.
Is he on?
He will
He
be.
did say he's joined it, so, but that's the.
Is absent but joining us on Zoom. Can I say that?
I don't know, I saw him. Jason, our council liaison is coming via Zoom, so that means he's just a citizen. So we say he's absent.
Well, yeah, I mean, he can, I don't know. I think from a training perspective, if they want to participate and talk, they can. What we've said is for sure you can't vote. There's sort of an army with peer review. I think a lot of people said, yeah.
So I do things in the right order. I neglected to print that.
Thank you. Good. Hasn't been too many things on the agenda. Yeah.
That'd be a nice addition here, it seems like
I-
a pretty good location.
I'm excited. I grew up having Dunkin' Donuts all the time, so that's a
Did
good.
you grow up out east?
Yeah.
Okay.
It's the only coffee my parents drank, so.
Okay. Pam was real happy to see. I mean, there's one over off of 61 over
Yep.
there.
Yeah, I go over there sometimes if I'm really. Yeah. I'll make the loop to Dunkin' Donuts and then go to Donut Hut in Little Canada and then come back around. Have you ever been to Donut Hut over there?
No.
It's really good. It's on, I don't know what the road is.
I know there used to be kind of a
Recording in progress.
on County Road E right near 61. But that was kind of a odd neighborhood where you kind of.
Yeah, I don't, it is,
Recording in progress.
It's
What's that?
going north on 35.
Yep.
Yes. And there's the exit for Little Canada. Whatever that road is, it's just off of that, towards the west. It's over there.
Oh, excellent, thank you.
Yeah, yeah. Thank you. Yeah. Yeah, we go there a lot because my kids love them. There's nothing special, but really just good tasting donuts. So. No.
See, it's like I've been hesitating to do that for ages, you know, it's always been
Yeah,
all that,
that
put it
sounds,
off and off.
yeah. So what places are you gonna see?
We're gonna start in Athens and have a little time there, and then get on the ship and cruise to Israel and check out Jerusalem
Yeah,
and Haifa,
yeah,
and then over to let's see, a couple of Greek islands, Cyprus, and
okay,
which is that mixed
yeah.
island, and then I'm trying to think of Rhodes.
Oh, yeah.
Rhodes, and then a couple of land spots, and over to Istanbul for a day.
Wow.
Yeah, and then back to Athens.
That sounds amazing. Oh my gosh.
Should be a lot of fun. We got some fun excursions and stuff, so
Yeah.
it'll be interesting.
Wow. Very cool. That's like a once
Gotta
in a
make up for
lifetime.
the lost time with, 3 years in
Yeah,
Australia.
yeah. Did you guys travel a lot before that?
We usually do one big trip and then a smaller one a year.
Yeah.
And as a matter of fact, when COVID kind of hit, we were down in, or I was down in Dominican Republic.
Oh, wow.
Habitat for Humanity.
Oh, yeah,
And then
yeah.
went to Florida and spent some time in Florida.
Yeah.
And then it was like, okay, no more vacation.
Wow, that sounds amazing. Very cool.
How about you? How's your family doing?
Yeah, they're doing really well.
Hanging in there for this winter?
Yeah, it's been a long winter. It's been, I love the winter for December, November, December, January. February, I'm starting to get a little tired of it, and then now March, it's like,
Yeah, definitely.
but yeah, we're doing good. My kids are just getting stir crazy a little bit. And, yeah, the littlest one, it's hard to even take him outside, when it's really cold because he'll strip his gloves off and he takes his scarf off and then he just gets so cold right away. So we don't really can't do a whole lot outside. So we've been doing
Commission meeting of March 2nd, 2023. So, something not officially on the agenda, I suppose I should wait till we have the agenda approved, shouldn't I? There's not a lot on the agenda tonight, so I would seek a motion to adopt the agenda as written.
We should do roll call first.
Oh, we should do roll call. You know, sequencing, right? Why don't you do roll call, Brandy? Thank you. Or Chris,
I'll take. Chair Blees,
here.
Vice Chair Wise,
Here?
Commissioner Brenna is absent today. Commissioner Muick,
Present?
City Council Liaison Nordby is absent, but with us via Zoom today. And for staff present today, we have Community Development Director Howe and Planning Commission Secretary Cherney.
And I believe we are welcoming a new commission member.
His appointment is scheduled on the city council agenda for next week, so it is not official.
Excellent, not official. Well, I guess that's clear. Thank you. Then he's here to participate in our training, which is excellent. With that, then I would seek a motion to adopt the agenda.
I'll second.
Moved by Commissioner Muick, seconded by Commissioner Weiss. All in favor?
Aye.
We are good. Sort of doing things in order, or attempting to do things in order. Am I missing anything so far, besides the fact that we're all here?
Nope, we're rolling.
Almost all here. Then, in that case, I would like to do a presentation. So, Rick Gelman is here. Rick, we had a chance to be on the commission together for better part of 3 years, about 3 years, I think. And be neighbors besides, which I appreciate. And I always have appreciated your input and your knowledge and the things that you've brought to the commission. And just so you know, I still have your phone number. So I can reach out when I'm really puzzled about things. If you would come forward, I would appreciate that. We'd probably, should I go over to the mic? To make this a little bit more formal, to make this presentation in honor of your 8 years of service to the Planning Commission, and I expect years of other service, not quite so formalized. We have this certificate and lovely prize with the North St. Paul on it. I don't know what you would call this. It's a crystal. A crystal cube. Crystal cube. So it probably works better than a crystal ball, I'm guessing.
Very nice.
At least it won't roll away. You have anything you want to say?
Well, I'd like to say that it really was a rewarding experience, and I hope that I was able to contribute a lot to the community. I think it's a fantastic city to live in, and a lot of great people, and fantastic things going on in the city. And it's been a pleasure working with the people on the commission, and I think we've got some really good people here, and thoughtful, and that's the kind of thing that I think really helps a city be able to move ahead. And so that's great.
Appreciate
you.
that.
Thank you.
You want to do a picture?
Yeah.
You want this showing up for any reason?
If you can, that's fine too.
Because I could probably do this.
Oh, yeah, that works.
Manual Zoom.
Congratulations, Rick.
I trust
you.
you will
That's very nice.
continue to be involved in the community. No
Def-
doubt about it.
Yeah, I will.
After your Mediterranean cruise is over, then you can come back.
Brandy, that reminds me, didn't we talk a while
Congratulations, thank
back
you.
about some sort of regular recognition for commission members? And I'm wondering whether that was taken to the city council and if we heard anything on that.
Well, this is the outcome of that discussion. So
Oh,
we
okay.
will, when we have commissioners retire or resign, then we will make sure that there is recognition appropriate to their tenure.
Okay, so, great, thank you.
Excellent. With that, let's move on to approval of minutes from our last meeting, which was only, what, 3 weeks ago? Something like that? Guess I'm not measuring the weeks so much. Yeah, it was February 9th, so guess it was about 3 weeks ago. I did not see anything in meeting minutes from that special meeting that I would suggest changing. Did anyone else find anything?
I had nothing.
Eric is not here to defend himself, so that being the case, I would seek a motion to approve the minutes as written.
I'll move to approve the minutes from
And I'll
February.
second.
I appreciate that you guys take turns. Motion by Commissioner Wise, second by Commissioner Muick. All in favor? Aye.
Aye.
And opposed? None. With that, I think we're to meeting open to the public. And it would seem that unless there's somebody on the Zoom,
The only person on Zoom,
No one
I
here.
believe, is our council liaison. So he's just here to listen and potentially participate
Okay.
in the discussion if necessary.
okay? Excellent. With that, there being no members of the public and no public hearings, we are slamming through this agenda and we're to item 8. Oh, that, I appreciate that.
Thank you, Rick.
Thanks, Rick.
Thank you. Have fun on your trip.
Good evening, members of the Planning Commission. My name is Soren Maddock. I'm the city attorney for North St. Paul. I'm with the law firm of Campbell Knutson. I've been working with North St. Paul now since about 2015 on all general matters for the city. But candidly, one of the primary things I work with the city on is your planning and zoning items. One of the heavy items in rotation for a city council meeting is development, and you play a large part in that. So what we wanted to do tonight at Brandy's request is go over some training materials. It's been a while since I've done a training for the Planning Commission. I don't recall candidly if any of you were on the Planning Commission the last time we had a training or not.
I had just started.
Because
Just
I would
started?
be, I would.
Remember when
oh,
that
yeah.
was?
It would be 3 years ago.
Was it 3?
Yeah.
I almost put it longer than that, but
Yeah.
here we are.
Yep.
So what I've done is I've put together some materials. I've actually, if on the front page it's incorrect, it says December of '22. What I did is I went over this once we hired Brandy. I met with Brandy and Brian just to make sure that Brandy and I were on the same page in terms of, you know, where our heads are at in terms of how we process planning and zoning applications. And that was a good meeting, and what we decided to do was bring that information to you to discuss here. What I plan on doing is going through the entire packet before you. I'm not a sit and read each paragraph to you. You've got it. I'll go and kind of hit the highlights. What I think works the best, especially in this kind of setting, is if we have questions, let's stop, let's discuss it. And then either while we're in it or when we get done, if you think it helps to go over some examples or just some, hey, I've had a question about it, let's do that too. The one thing I don't want to do is if there are pending applications, I'd prefer not to discuss those here tonight, just out of respect for the due process of making sure those come to you in due course and through the normal process. But I do think it's fair game if there's ones you've handled in the past or before you were on the Planning Commission, had questions about, we can certainly use those as examples to discuss. So with that, on the page, it's page 2, land use planning. One of the things to remember for a city is we sometimes think government has all of these powers, things that you can do. And certainly cities do have a lot of authority under the Planning Act, but what's important to remember is a city does not have any inherent authority. You have exactly what the state legislature has given you. And so the state legislature has passed laws and through the form of statutes to tell you exactly what you can do. And what you have in paragraph B is the Metropolitan Land Use Planning Act. You are subject to that. Keeping in mind that when you're in the 7-county metro area, one of the things that governs is the idea behind a comprehensive plan. I don't know if you guys have worked with your comp plan yet. If you haven't, what that is that's your base document. It's a very comprehensive plan that says, hey, here's what we've got in the city, perhaps here's what we would like the city to look like in the future, start doing some forecasting, things of that nature. From my standpoint, I don't get overly involved in the comprehensive plan. It's really more of a planning document, not a strictly read document. It is meant to be sort of aspirational in nature, things of that nature. On the bottom, one of the things what the law says is that there's when you adopt a comprehensive plan, what you then need to do is figure out how to implement it. And that is what you use your zoning and subdivision ordinance for. And your comprehensive plan cannot be inconsistent with those conditions when you specifically implement the zoning. The idea is you take the base document that says here's what we want to look like. Your zoning ordinance and subdivision regulations are supposed to be the specific details that spell out exactly how that comprehensive plan is implemented. So I'd encourage you to think about that as we move forward. I don't know if there's questions on the comprehensive plan. One thing to keep in mind about it is when we amend the comprehensive plan, it does take what we often refer to as a supermajority vote by the city council, not necessarily the planning commission, but by the council, which means 4 out of 5 instead of the regular 3 out of 5. It also, yeah. It also does take review by the Met Council, so it's not just necessarily review by the city, but by the Met Council, and that is in the 7-county metro. So for folks who have lived outside, if you came here from Stearns County, Met Council's not a factor, but in Ramsey County it is. And what they do is they compare your comp plan to some of their goals that they want to see through the 7-county metro area.
Okay, I know the comp plan is generally updated every 10 years, I believe, in the year ending in 8, is that right? So 2028 would be the next one?
Yeah, I think that's when it
Right.
would have.
Do we ever do them a full comp plan at any other time? You know, is there anything that kicks off another comp plan, or is it just always an amendment until the next full plan?
I would say that there's nothing that precipitates a holistic view like you do in your 8s, if you will. However, what I do see at times is if someone has a development coming in, sometimes it does require a comp plan amendment. Usually what I see is someone says, look, this is zoned for a certain residential type. I'm anticipating something more with more density, more units. And after some feedback, either from council through a concept plan or in talking with staff, sometimes we amend the comp plan to upzone it, if you will, to allow more density. I haven't really seen that with uses so much, but sometimes that can be. So it's usually if you're looking to intensify the use, but you certainly can as part of a zoning application. And in some communities, candidly, for a while, it was almost like part of every application was a comp plan amendment.
The other question I've got is, as far as neighboring jurisdictions, do we do any work to try to make sure that there is cohesiveness between jurisdictional boundaries? In particular, what I'm thinking of is, for example, were there to be say, a large residential development that was partially in North St. Paul and partially in Oakdale or something like that, would, it wouldn't make sense for them to have two different comp plan requirements for two different cities because they straddle the city line.
We do put the comp plan out for surrounding jurisdictions review and comment, and that's where I've seen it come up. It is purely a North St. Paul document for your review and approval, but certainly multiple jurisdictions weigh in on it when you go to amend it or do your proper planning. Because certainly if you just sort of myopically cut the line and don't, that's not part of planning, because you've got traffic and other things. And to your point, if it splits down the neighborhood, it makes sense to look at that too. So I've seen it as more of a holistic document with the ability to comment on it, not approve it from the neighboring jurisdictions.
Right, okay, thank you.
Yeah, and we review them as well when neighbors amend theirs.
Right.
I think it might be a state requirement to have that shared jurisdictional.
There's a list of who you have to serve. I don't have that committed to memory, but certainly your neighboring jurisdictions are on it.
Well, actually, I probably know most of it because I work for MnDOT, and I'm one of the people that reviews all the Met Council comp plans. It's just, it's one thing to be on the reviewing side, it's another thing to be on the construction side, as it were.
Yep.
So,
No, that's a good point.
Does the Met Council need to approve amendments?
Yes. Yep. Any
Any change
they
you
bless it. When you change it, it goes to Met Council. And depending on the scope of the change, depends on the time of review, minor and easier, quick. But if you do a substantive change, it may take a little time. They are getting better. One of the complaints was the amount of time it took to get through Met Council and slowing down projects. But in my opinion, they've gotten better.
yeah, I know if it goes through MnDOT, it takes us a minimum of 3 weeks to get something done unless it's really easy.
Yeah.
Just because of all the different departments it has to go to for comment and then to come back to us to put together a letter to go out.
No one's complaining about 3 weeks. It's when
No,
it's in
no.
months.
Yeah.
Page 3, role of the Planning Commission. There are probably more items that you guys could address. These are all the statutory items. You'll see that there's a lot of mention to the comprehensive plan. You are an advisory body to the city council. When I think of, I didn't include it in here, I don't believe, but we used to have sort of this pyramid that showed level of discretion when you're making decisions. And what I view the Planning Commission as is, this is sort of a public body's first crack at an application after staff has reviewed it. Brandy intakes it, compares it to the code, gives any application a professional review. What you get is a professional report, sometimes with recommendations, sometimes not. What you're doing is taking any public input and sort of as an advisory body. So you're starting to sand off some of the edges of that application and understanding what the issues are so you can make a good recommendation to the city council on that application. And so you are advisory in that respect, but that is an important role here. I would say that this has come up more in North St. Paul than any other community. If you take a look at 2F, there is actually a provision that says when we buy and sell land that is supposed to come to you. I don't think that is really necessarily the best use of Planning Commission time. You don't have a budget or financial, you're more of a planning agency in my opinion. City Council can waive that review by you. Sometimes that slows things down. Sometimes you might not even know why we're looking at it. So the City Council can waive that requirement by a 2/3 vote, and candidly, we usually do put that in the resolution. So while there is a statutory mention of that, it's rare that it comes to you. It has in the past, but it is candidly something that usually goes right to the City Council. Any other zoning ordinance amendments, things of that nature will be coming to you, and other planning applications as you've started to see them. Moving on to page 4, so zoning, this is where we start talking about the zoning ordinance and implementing the comprehensive plan. You can see A and B are sort of just the overall purpose. One of the things this used to be just sort of canned language that we would quickly go over, but what I'm seeing is more need to drill down on this a little bit. As we see zoning ordinances and as zoning gets more complicated, what I'm starting to see is more and more layers onto what we try and put into zoning ordinances. Item C is a good reminder of what we do with zoning. It is an opportunity to say what use makes sense here. So, oftentimes if we have a residential area, we don't necessarily want it butting up against an industrial zone. The two uses aren't compatible. Maybe we have commercial buffering it. It does go to the location, height, bulk, density, things of that nature. That is classic zoning. Where communities have, in my opinion, got into trouble is where we go too far into some of the aesthetics and things of that nature, building materials, all of that. And what I will tell you is it's not uncommon to have those items in zoning ordinances, but at the legislature right now, one of the complaints from builders and developers is that communities have gone too far. I do think in this legislative session, we are going to see things get peeled back on that. And so, we'll wait and see. I'm not here to forecast what the legislature's going to do. I'm the last person you should ask candidly on that. But I do think there's going to be substantial changes.
Okay, is that the form-based zoning then, or?
No, when I think of form-based, what I think of is sort of here's your box, here's the sites and stuff, and a lot of form-based candidly does not care about use.
Right.
And I don't know, I've had multiple debates about form-based. I'm not a fan of it because I usually get called in when there's a problem, and candidly, folks care about whether they live next to a restaurant and or a gas station or traffic counts, headlights, speakers from drive-throughs, things of that nature. It's more than height, structure, setbacks. They care about the land use. And so that is something that we focus on in C. We do have a zoning map which shows you your various districts. When you have zoning districts, it is important to remember that you need to be somewhat, well, not somewhat, you need to be uniform within that district. So what we need to do is make sure that if you come in to build a home, that the rules, and you're in the same zoning district, that the rules that apply to you apply to everyone else. That is one of the just fundamental aspects of good governance, is that if so-and-so gets it, I get the same crack at it, and so it needs to be uniform within those districts. And I haven't run into problems with that. I have seen sometimes where folks will say, look, we've just got so many gas stations in this district. Well, if it's an allowed use, it's an allowed use, and one of the ideas is government's role is to say what are the acceptable uses. It's the market's choice to decide how many gas stations should be there, things of that nature. So sort of that equilibrium. If it's an allowed use, it's an allowed use. If so-and-so gets to have a certain height, we all do. And that should just be black letter in your codes.
I have a question about the zoning map, because we were talking about it at our last meeting just briefly. I don't know if any zoning changes have occurred that would require us to change the zoning map. I don't have record of that, and I don't think, Brandy, you were kind of looking into it, but there didn't seem to be anything in particular. But I do know that there have been bits and pieces of property line changes, properties getting combined, things like that. Is it important that those sorts of property line issues get documented accurately on a zoning map, or does that really not matter?
Zoning map, well, I would say that the zoning map doesn't care about property lines, but that's not completely accurate, because usually you do try and line up your zoning designations with features like property lines or roads or just natural geographical areas. But if someone comes in and adjusts a property line, that has no impact on the zoning map.
Okay.
Those lines remain. Now, what I would say is you do run into problems if you do some land assimilation and you have split zoning through your new parcel. It's very common to come in and request a zoning amendment, which would then adjust the map.
And how important is it that we make adjustments to the map if something like that happens? Is it important to get it done in a short period of time?
Well, I think so, right? You want your map to be accurate, so
Yeah.
does it take a little time to catch up? Sometimes, but if you adjust your zoning district, that should be part of what you adjust.
Okay.
That's the document that tells you where the lines are.
Is there a, say, a statute of limitations for how long a variance could affect the neighborhood? What I'm thinking about is in my particular circumstance, the city council or somebody about 15 or 20 years ago allowed my property to be subdivided, and the person that built the new house next to me built a house that is much larger and higher than anything else in the neighborhood. So I'm assuming that they got a variance unless there wasn't zoning in place at that time, and I'm pretty sure there was. So does that mean that other people in the neighborhood could come in and say, this house is a two-story and its roof line is 10 feet higher than what current zoning allows, so I should be able to get it too? Or is there a limit to say, well, this was granted 10, 15, 20 years ago, so it's no longer can be used as an example of what might be allowed by variance?
So my answer to that would be, is each and every variance, to the extent that situation required a variance, is unique. You have not set a precedent, you have not set now that's the new standard. The zoning regulations stand. A community can adjust their zoning criteria whenever you see fit. That's a legislative decision, and we'll cover that. Now, do I think as a practical matter, if you get a variance to increase your height, one of the things, and we'll cover this, not to jump around too much, but one of the things you do is it consistent with the neighborhood? Well, the next person who comes in says, well, he got it. Now, if you can reasonably, as a council or planning commission, say, yeah, but this is different, well, then you distinguish it. If it looks the same, are you bound to give it? No, but you have to be able to answer why that person and not me. In terms of statute of limitations, there's nothing.
So a variance is just for that one piece of
That's
property, that one time, and
Yep.
nothing else necessarily applies because it was granted.
No.
Okay.
And keeping in mind that zoning may change the next year, 10 years later, whatever, and so the analysis changes, the law can change, things like councils change, how you analyze the variance might change. So no.
Randy, I'm not asking for that. It just, it's just kind of made me wonder.
So the process for amending zoning ordinances, I'm on F3 now on page 5, does require public hearing. You give notice to the public. They have an opportunity to come in and comment on it. That is one of the things that Brandy would put together for you, in my experience, for you to comment on. It's your job to, I think, at a policy level, make sure you're okay with what's being proposed. And then obviously wordsmithing if necessary. So when you draft a zoning ordinance, what you'd notice is if you opened up your current code, you'd see R whatever, and you'd see some statements of here's what we're going to do to try and promote orderly development in this district, and we'll start with here's the permitted uses. So when you go down to the bottom of page 5, what you see are here are the permitted uses and how we look at permitted uses. The idea behind a permitted use is what we are saying is this is the core of what we want to see in this zoning district. Those are the uses that don't need to come to you, they don't need to come to the council. It's just, think of a house in a residential district that meets all of your zoning criteria. You get it as a matter of right, come in, get your building permit, no fuss, now go build it. There is no real way to deny a permitted use. What the law presumes is once you've gone through the process of adopting a zoning ordinance based on your comp plan, when you say that you get this, it's a permitted use, then the idea is that's allowed. Someone shouldn't be put through the ringer or on any sort of process. Now, if they want to go closer to the property line than what's allowed, then you need a variance. But if you meet the law, you get what you're asking for, and that's the end of it, period. Those are permitted uses. You have no discretion to deny them. It does not matter if during public forum, 10 neighbors come in and say, I hate the fact that this is a house going in there. It used to be a vacant lot. The kids play there. Now what are we going to do? Does not matter. They get the house, period. Accessory uses. These are uses, I'm on page 6, number 2. These are things that you see that go along with a permitted use. So The example I would give is you cannot have an accessory use without a primary permitted use. So if you think of a home with a detached garage, the detached garage is usually listed as an accessory use. You do not get that accessory use on that lot until the primary permitted use shows up. No accessory without a permitted primary use. It has to be accessory to something. This idea came up a little bit, not necessarily in North St. Paul, but in other communities where someone would buy a lot. Hey, I'm not sure how I want to build. I want to test it a little bit. Let me go build the toy box where I store my stuff, and then I'll kind of figure it out. Well, we found that that wasn't necessarily compatible with the neighbors. Other things happen. So the idea is you bought this as a residential lot. You're going to use it as a residential lot first, and then the accessory, the sport courts, the other things can show up, but not before the permitted use. And that's the same with, say, like the little Menard sheds or things like that. You get your accessory once the permitted shows up. Conditional uses, those are the uses, those you will see, the statute does require a public hearing for those. Conditional uses, much like permitted and accessory, are those things where you have sat back and said, we think these uses should be allowed in this area, but we want the public's input. It's a little bit more intense. So maybe it's not the house, maybe it's the gas station, or maybe it's the coffee shop or something like that, that we think is compatible with the other uses, but we want to be able to, after listening to the public comment, put other conditions on it. So again, if someone comes in and says, I'm applying for a conditional use permit, it's a gas station. If you say, well, I don't think gas stations are appropriate, that is a loser argument. By the very nature of your zoning ordinance, you've already decided the use is appropriate, but you can put conditions on it. Now, if there are things like a traffic study that show, well, yes, gas stations are appropriate, but this one's going to generate so much traffic, well, then that would be a basis to deny it. But denying conditional use permits are incredibly difficult because the law says, look, you've already decided this use is presumed to be okay. So you're going to have to find a performance standard or some other criteria to deny it. What is easier, candidly, is if you decide that there are problems with the proposed use, is to put conditions on there to minimize your concerns. So for example, one of the things I've seen is with drive-throughs, you have concerns from the neighbors about noise and or headlights from going through. The answer isn't necessarily to deny that conditional use permit. It's to put hours of operation on the microphone so that you don't have to listen to it too late. It is putting up berms or trees to knock out the headlights. So those are reasonable conditions. One of the things when you impose conditions on a CUP is the conditions have to be reasonably related to the application. So you'll hear folks like me start talking about a nexus. So if you want to make sure that the headlights don't go blaring into the neighbor's property on the drive-through, putting in trees or other berming to knock out the headlights, well, there's a nexus. There's a reason we're requiring it. It's not just because. So where we sometimes have problems is if the neighbors really don't like a project, they'll ask for a bunch of things and conditions. Those conditions may make sense, but if they're just conditions, that you have to be able to explain why it's necessary for that developer or builder to impose that condition and financial resources towards that fix. It has to be fixing something, I guess is the point.
Can I get clarification on that since you're
Sure.
on it? So the rationale, is that something that takes place in the staff report or the minutes or both
Well,
for those conditions?
yes, it should be, or if we talk about it on the record, I mean, if it's something that perhaps you didn't think about, but through the public hearing, oh, that makes sense to me, then we would discuss it and we would add it presumably to the approval resolution, based on, it can't be based on neighborhood concerns necessarily, but it can be based on the fact that lights will be pitched to the neighboring places. We're going to block those headlights, therefore berming. That's how that would flow on that example. Anyway.
So you would potentially document that in your report,
I would.
that you aren't just requiring a berm, but you're requiring a berm for a purpose.
That's
and
correct.
you describe the purpose.
Yes.
That makes sense.
All of that's I think I heard you that it's captured in the resolution.
It should be, Now, what you need if we get to the point where we're ever challenged, is a conditional, so when we think of your comp plan or your zoning ordinance, those are referred to legally as legislative decisions. And what the courts have said is the city council ultimately, as an elected body, is allowed to adopt these items, and we are going to defer to your judgment. We're not going to come in and second guess your policies that you're putting in place. It's a legislative decision, that's why you're elected. Things like conditional use permits or variances are what are known as quasi-judicial, meaning you've already put out the law. The law is there, it's your zoning ordinance. So as you sit here, are you applying the law correctly to that application? And so it's a different review, quasi-judicial. Again, so what the reviewing court would say is, did you properly apply your review of the zoning ordinance to the facts given? And that's the review. And so what they do is, if there's a challenge, it is not some jury trial, there's not testimony. What the court does is they take the record that's developed here, it's what's known as a record review, and they review the decision, which is in part developed by the Planning Commission. We take all of the testimony here and records generated to the city council and ultimately to the court. And so what they're going to do, to your point, is, hey, I don't think it's fair that I have to have a berm. Well, right here in the record, it shows if we don't put in that berm, those headlights go into the neighbor's window. That is why we're requiring the berm. Well, then that's a reasonable way to do it, and that should pass any sort of review at a quasi-judicial level. And so that's why it's important to document it.
What about in a situation like that where we didn't catch it and the city starts getting complaints from residents saying, these headlights are going into our living room? What level is that handled at? Is that something that we would get involved with, or?
Once you've issued the permit, it's issued. And if you've missed it, you've missed it. Now, that's a bit of an overstatement, but not by much. There's no real redos on these things. You're expected to thoroughly examine it, because when that applicant walks out, they want to know, that's not the Columbo situation. Oh,
Right.
By the way, no, I reasonably know, I now have my investment, I understand what it's going to take to build this. We don't get to keep layering on. There are, on your bigger projects, when you see a development contract, there will be references to engineered plans, things of that. Some of those are fluid. I mean, let's face it, construction evolves. But things like berms and other planning requirements, we're not able to readjust very easily. If they come back to us for a reason, well, now they've opened the door. But if they just take their approvals and walk, that's what they get. Then there's the idea of uses not permitted in a zoning district. One thing to remember is if someone comes in and says, well, I want to do this here, you have to look in your list of allowed uses, and it has to be within there. You can't say, I don't really see it in here, but we'll just do this as a CUP. Not an option. So the way a zoning ordinance works is it lists what's allowed, and it presumes if it's not on your list, it's not allowed. Now, the nice thing about zoning ordinances is you control the rule book. If when someone comes in and says, yeah, but this would make sense, they get to petition you for that. And I would encourage you to add that to the zoning ordinance. Some of our zoning ordinances read, well, if it's not listed but it makes sense to the planning or zoning administrator, we can do it. I'm moderately okay with that. My preference is to spell it out and have it be in the list of allowed uses, because ultimately, when we go back to basic governance, we need to make sure that it's equally and consistently applied. So that has always been my preference.
Okay.
We want to be flexible, but we also want to make sure we're consistent.
Is that something that can be handled with an adjustment, or is that something that has to be handled with the next issuance of the comp plan?
Well, just because you amend your zoning ordinance doesn't mean it'll be a comp plan amendment. It depends on how, where I've seen it is if you've got a commercial district, you specifically spell out certain types of commercial uses. Well, I can remember when sport courts weren't a thing. And so, yes, it makes sense. Yes, it's kind of accessory to a residential, but it's a little bit bigger. It's like a tennis court. It's a version of it. Well, we just amended zoning ordinances to say sport courts of this size are allowed to meet these setbacks, because they started to become a thing. and we wanted to make sure we were consistent about it. That
Doesn't
didn't
have to wait-
require.
Doesn't
comp
have to
plan.
wait for the comp plan then.
No, absolutely not. No, no. None of this is written in stone. If there's a good idea that is fair and makes sense, amend your rules. It is not uncommon to simultaneously have an application be accompanied with a request for zoning or change. And so the way you do that is the first thing you address is the zoning ordinance amendment. If that fails, well, the rest of the application is going to fail. If that passes, then off we go on to the next request. All right. Interim uses at the bottom of page 6. Something that I candidly like but aren't often used. One of the things, just quickly going back to conditional uses, and we'll cover this a little bit more, is on the next page, is when a conditional use permit is issued, we kind of talked about statute of limitations. That permit is issued to the property. And so you take it and you record it against the property. And so if the property is sold later on, that conditional use permit stays. It doesn't terminate because there's a new owner. So it's what we would call runs with the land. And there is nothing you can do in that CUP to make it so that it, quote, sunsets or terminates or things like that. Once you issue that CUP, so long as they comply or whoever owns the property complies with the conditions, that CUP stays. Even if you modify your zoning ordinance. So if we say gas stations are allowed in zoning district A, if you later on change your mind, no gas stations in zoning A, they get to continue to operate that gas station. It becomes what's called a lawful non-conforming use. You don't get to take it away from them.
Can I get clarification on that? So if the use ceases to operate, is that the point that the CUP no
Only
longer?
if it's become non-conforming. So if
So
you have,
it's perpetuity then? Wow, okay.
yeah, it runs with the land, yep. Now, we have had provisions in there where if you're awarded the CUP or you get the CUP and you don't take advantage of it within a year, pull the building permits, we've had the CUP terminate. But if you're operating the gas station and zoning continues to allow it, I don't know how it would be terminated at that point because it's an allowed use, you have your CUP. If zoning changes so it becomes non-conforming and you abandon it, the law says if you abandon it for over a year, you lose that right. Now, abandonment is tricky and candidly legally really ill-defined because how abandoned does it have to be? Does it that you're just not selling gas, but it's operating in some other gas station capacity on the retail side? I don't know. That's been hard. That's been tricky.
Yeah, 'cause I know with MnDOT, we've got I think it's a 25% increase limiting factor on things, but that may be because of traffic generated, so it might not apply to city codes. But like if a development adds like 25% or more to their square footage, or they bring in an additional use that's going to generate that much more traffic, we have the ability to deny them access to the property if it's that much of a change. But like I said, that might be because that's traffic and not necessarily to like zoning and that type of thing.
Yeah, I haven't seen that happen. I'm sure you have, but I haven't. Candidly, because well, not always, but a lot of the roads that I've seen developments go to don't go directly to a MnDOT road. They
Yeah.
go a city road, sometimes a county. Interim uses, unlike CUPs, you can do exactly what I just said you can't do with a CUP. You could terminate an IUP for change in ownership, for change in zoning, things like that. And so while that gives a community more flexibility, a lot of developers come back and say, well, wait a minute, I am not investing $2 million in a gas station if because you get a whim and change the zoning, I have to stop operating it. So where I've seen IUPs used primarily is gravel pits, sometimes kennels, and then sometimes areas where we're expecting redevelopment. The idea being this area is ripe for redevelopment. We want you to use it till we're ready to change it into something else. That's fine, but understand, we're going to turn this area into something else. It's coming, and when we rezone it, this use is done. That's where I've seen it used primarily. But I would say that it doesn't happen often. It ends up being more of a conceptual idea. And again, if your code doesn't list something as an IUP, you can't just say, you know, I wish we could make this go away, we'll just call it an IUP. Your code has to specifically call it out as an IUP in the zoning ordinance.
Does the zoning ordinance have to or is there something that specifies that we can issue an IUP and that we can't issue if it's not written in the code somewhere?
So keep in mind, when you open it up, you look at your zoning districts. It has permitted uses, accessory uses, conditional uses. If there's no IUPs listed, there's no IUP to give.
Okay,
Because if it's not listed, it's prohibited.
so that might be something we might want to look through the code to see if there may be situations where we might want to list the availability of an IUP for the future.
Yeah, you always can, you know, if there's things where you're looking at that it would make sense. The examples I've given is where you're not limited to those, that's just where I've primarily seen it used. Again, the idea, I'm not gonna make the investment in a new brick and mortar if you can take it away from me. All right, page 7, conditional uses. We've really already kind of covered this. You know, what is it? It's a use that's already been contemplated and listed in your zoning district. We've talked about the nexus requirement. If you place conditions on it, there does need to be a nexus. Citizen asks, or hey, this would be nice, are not, while it appeases the crowd that's before you, is not legally a valid reason to do it. Time limits, you cannot say you get this CUP for a year, 2 years, or until change of ownership. It runs with the land, period. And until they violate a condition, they get to keep it. You are statutorily required to do notice to a certain group. I think it's 350 feet, and they get a public hearing. Keeping in mind that limited discretion with CUPs, citizen opposition to a project is not a valid reason to deny a CUP. What is constantly hard about land use items is when there's a room full of people saying, don't do this, you're changing the intent of my neighborhood, the traffic's going to increase, it's going to change the character. The idea is that your zoning ordinance already contemplates the idea that that CUP is allowed with reasonable conditions. Simply having people tell you that it's going to change my neighborhood or that I don't want it is not a valid reason to deny that CUP. It's politically efficient and it feels better, but it is not legally valid, and if challenged, we would just flat out lose on that. We've kind of touched on this. CUPs are a quasi-judicial decision. The idea being you, in effect, act like judges standing here or sitting here in a panel. You are going to examine the zoning ordinance. You're going to examine the facts as brought to you by the planning staff and the applicant and make a decision as to whether their application meets the intent, spirit, and letter of the law of the zoning ordinance and rule or actually advise the council accordingly or make a recommendation, that is. Questions on that? I feel like we've kind of covered that, so I buzzed through that. Okay. Variances. So variances, like CUPs, are a quasi-judicial decision. Variance is, I know your zoning ordinance says I need to be 10 feet from the property line. I really think I can only be 5 feet. It is incumbent upon the applicant to tell you and show you why they should have an exception to the rule, because that's what a variance is. We say, here's the law. They say, but I need an exception to the law. And it is up to them to be able to prove it. In Minnesota, we have what's called a practical difficulties. At some point, I should probably update letter B we talk about in 2011. There's this new test. 2011 doesn't feel so new anymore. It used to be hardship analysis before that. Now it's practical difficulties. What is important, and I've given Brandy a kind of a template for variances that puts us through the exercise of going through and looking at what qualifies and what it takes to get a practical difficulty. So if you flip the page to page 9, letter D, statutory considerations, it's a 5-part test under the statute. So you see 1 and 2, and then paragraph 3, which is it has 3 subsets under there of what constitutes a practical difficulty. When you go through a variance, one of the things I would encourage you to think about is truly, so for example, the first line there is the variance is in harmony with the general intent and purpose of this ordinance. When you're examining an application, don't just make summary comments. Someone comes in and says, I want to build a house 5 feet when 10 feet is required. If you look at it and you kind of like it, seems fair, don't just simply, well, yeah, it looks like the variance is in harmony with the general intent and the purpose. What the law wants you to do is really do a particularized analysis. And so an example of that would be the applicant is asking to build a home. This is a residential area where there are plenty of homes in the area. A home is consistent with this neighborhood. We've looked at the 5 surrounding properties and we've noticed that at least one of the homes is actually closer than 10 feet to the property line. This is consistent with the neighborhood. Things like that. And you may not get the other home closer, but you can start to create an analysis that really calls out why this is okay in this particular instance. Don't just take these statements. So like for on number 2, the variance is consistent with the comprehensive plan. I would encourage you not to just regurgitate that. We find that the variance is consistent with the comprehensive plan. To me, a better standard or criteria is the comprehensive plan contemplates single-family zoning in this area. We have zoned it single-family home. What they're contemplating doing is building a single-family home that is consistent with the neighboring properties, same size, same look, same feel. You start to add that analysis. Any reviewing court at that point knows you took your job serious and you did the homework. I always talk about this in terms of if you ever had a picky math teacher that always said, show me your work. Don't just give me the answer. This is where you show your work and don't just give an answer. Any questions on that? So what a reviewing court will look to do is see whether what you've made a decision as is whether it's arbitrary and capricious is the language. They won't second guess your decision as long as you explain why, but if you just do it in a summary fashion without any explanation, or if your explanation is not based on something in the record, then it becomes arbitrary and capricious. If you don't do any analysis at all, well then why did you do it? It seems rather arbitrary, and so that will be the nature of any review. What courts have said is, look, cities, you have the right to impose additional conditions on variances if you so choose. And so letter E, I believe, Brandy, I should have double checked this for tonight. Is this still our criteria for the variance? So if you do in fact impose additional criteria, you are required to go through those also. And courts have said, if you've taken the time to go above and beyond the statutory criteria and impose city code requirements, you are required to analyze them. Your lack of analysis on your own code is in and of itself arbitrary and capricious. What I'll say is I come and go, candidly, whether the additional criteria really get you anything. I think a lot of the analysis that when you do your city code provisions, you'll feel like you've already done it through the statutory analysis. I'd still encourage you to do it, even if some of the analysis is repetitive. Make sure you go through that exercise. On to page 10, discretion in granting or denying a variance from zoning. We talk about how the court is going to look to make sure that it's not an arbitrary decision. Courts will give communities broad discretion. They won't second guess what you've done, but again, you have to show your work and why you did it. One of the items to remember here is when you get an application, it is up to the applicant to show you why they deserve it. It is not your job to coach them through it or come up with reasons for them. They are the ones who are supposed to bring it forward. Now, if you see something in the report that you like and you support it, by all means, bring that out. but the applicant is supposed to be the one who makes their case before you. And that comes in the form of a staff report plus the applicant materials. Questions on variances? What I would say is variances is one of those areas where when I get the question, hey, Soren, can we grant this variance? Or, hey, Soren, can we deny this variance? My answer is yes, either way. But you do have to show why on either way. So it can at times be frustrating. It seems like one of those lawyer answers of, well, on the one hand, on the other, and I get it. But you do have discretion on the variance if you can explain why you're making your decision. Courts will defer to your decision-making process. And so that goes to some communities. One community in particular has not granted a variance in 10 years. They've said, we're not going to get into the habit of doing this. It's problematic. I work in a community that probably does 2 or 3 variances every single city council meeting. So my opinion is if you find yourself giving a bunch of variances to a city code provision, change the city code provision. Just codify it. Some communities take my advice, some don't.
So have you seen any areas in our community that kind of would fall into one of those categories?
I haven't. No, I haven't seen the consistent variance. You guys do some variances here and there, but I haven't seen anything that's been like, you know, why are we doing this? Or, you know, why is this provision so strict where, you know, we're always going to have to do a variance? I haven't seen that. Which is somewhat unique because North St. Paul's by and large built out. I know that doesn't feel that way with the new stuff going in, but by and large you're built out. And that's some of the hardest area to infill develop, meeting a new zoning ordinance. So I haven't seen it yet. Time limits. When I started practicing law, this was not in the books, but it became in the books. What the legislature found was one of the best ways to deal with a controversial project is to just slow play it and watch it die on the vine. So what the legislature did is said, hey, here's the deal. You're going to get 60 days to thumbs up or thumbs down. And if you haven't done it, they automatically get approved. Now, I think it's often referred to as the 60-day rule. In my opinion, it should be referred to as the 120-day rule because it's 60 days out of the box. We as a city can send out a letter and extend it another 60, although we have to do that in writing. Brandy tracks that for you and sends out that notice. But at the end of that 120, you have to make a decision, yes or no. And if you do not, that application is automatically approved as submitted without any of your conditions. And courts have strictly enforced this against cities. Day 121, and they've got an approved project, no ifs, ands, or buts. So it is important when we push these things through. That's why when we have snow emergencies, planning commission meetings get canceled, it can get dicey if we have to push things out another 30 days. We do get 120, but that's all we get. We can seek additional time from the applicant, but after the 120, it's completely up to them. We cannot mandate it.
I have a scenario for that. What if we fail to meet the 60-day rule and a site plan comes through, it gets approved without us having the opportunity to say yes or no? And let's say there's something inconsistent with it related to zoning, like a setback, for example. So their site plan's approved, then they come in for their building permit. Is there an opportunity at that point to rectify the site plan issue?
No, the argument is they get what they submitted.
So building permit only deals with the internal function of the building. Okay.
Yep. I mean, what they've submitted, yeah, you can't use your building permit to start enforcing your setbacks because the building code doesn't address that by and large. So that is the 60-day rule. It's there, we track it. I would say when this first came out, there was a lot of litigation on it because communities were getting tripped up on it. Basically, everyone knows, look, this is the deal. It's not a surprise to anyone. They track it, we keep track of it, we get things approved, we do any denials in writing. everyone pretty much knows the drill. I haven't seen anyone get stung by the 60-day/120-day rule at this point. Everyone's been trained up on it. Public hearings, you do have statutory and informal. You'll see the statutory ones on page 12, what are required. Amending the zoning ordinance, comp plan, preliminary plat, CUPs, IUPs. On the statutory side of things, you'll notice what's missing is variances. Variances are not statutorily required to have a public hearing. I would say that most cities, I work in the city of Plymouth, does not do a public hearing for variances, and they're not required to. They do something, I believe, that's called a public comment period, which looks like a public hearing. But statutorily, you are not required to do a public hearing for a variance. What I'd say is when we start talking about zoning things, there's this idea of, hey, there's this project going in, they need a variance, I'm a neighbor, I want to know about it. And most communities do the public hearing just so the public gets a chance to weigh in on it. It's odd to me that something like a variance doesn't statutorily require a public hearing. When I think of just if I lived next to a home and someone was going to squish it up as close as they could to the property line and the law doesn't require me as the neighbor to get notice about it, that feels odd to me, but that is in fact the status of the law. But that is why I think most communities in their zoning ordinance say variances will have a public hearing, much like you would for a CUP. But it is one of those things of note that it is not statutorily required, it's self-imposed. Due process, so we've talked about some of the items that are quasi-judicial in nature. On F, one of the things to remember is it is not uncommon, and the city of Minneapolis had to deal with this, when we know there's an application out there, neighbors, neighborhood, whoever may start talking about the project, and they may approach you on the planning commission and say, hey, what do you think about this project? Where's your head at on it? I hate it, I don't want it. I'd like to know that you're gonna support me on this or recommend to the council that they ought to deny it. Keeping in mind that these decisions are quasi-judicial in nature, the example I'd give you is this, is if you got a speeding ticket and you walked in and you're standing in front of the panel of judges and the judges said, you know what, I've already talked to the cop. He's assured me you're guilty and that's how I'm gonna rule on this thing. So no worry, if you've got anything to say, tell me. Well, it doesn't feel fair. Your due process has been abrogated. You didn't get a fair shot. People have already been talked to unilaterally. You've already expressed that you've made up your mind. The process hasn't been followed. So when you are in fact approached, if you are, by folks who want to talk to you about a project, whether it's the developer or the neighbors, I feel it's okay to listen and engage them on what their concerns are, but do not prejudge an application. Take in the information, but do not express an opinion on it. Do not sit there and say, yeah, I agree with you, this is the worst project. Oh my gosh, this is gonna follow up traffic. Boy, this is just gonna change the neighborhood. Your property values are gonna decrease, I'm convinced of it. All the things. It's okay to take in the information, but don't prejudge it. When you see the emails start flying around doing that, it's okay to observe them, it's okay to take it in, but again, do not sit and weigh in on those things. Questions on that point? That's a hard one because people want feedback. You know, I notice you haven't committed to that. Why not? I need to wait till the public hearing. Now, once everything's been presented and you've heard it, well, that is the exact time when you should weigh in with your opinion at that point. That is when you can talk about concerns of traffic, headlights, density, height, close to the property lines, all the things. But it has to be after you've had all the information brought to you, because as fairness dictates that you shouldn't be making a decision until you've heard both sides and given them equal time in front of you. All right. General considerations for you. We've got a couple things here. Conflicts of interest. If the applicant is also your employer, you should remove yourself. Some of this is common sense, although sometimes it just comes up. It's rather convenient to approve something and show your boss what a good employer you are. I assure you that's a conflict of interest. If for some reason you find yourself applying, no, you do not get to vote on your own application. If a household member is applying, you should remove yourself. Those are the very easy ones. The harder ones are when your brother, sister are applying, do you have a conflict of interest? And the law is actually grayer on that than I would like to admit. Do you gain financially from it? Well, it's just my brother. No. Is there an appearance of a conflict? Absolutely. Especially in communities the size of North St. Paul, it doesn't take long to figure out who's related to who. Candidly, even in the city of Plymouth of 80,000, it doesn't take long. I would encourage you to step aside from that decision at that point, and the logic being, you're a governing body, and one of the tenets of this is that the public has to trust the system. And if you sit here and judge something that you have blood relations to or employment ties to, even if we can figure out how to show you don't strictly have a conflict, you are shaking the confidence in the system, and it does not seem fair. If you feel like you have a conflict, that is one of the questions I can help answer and navigate through. But I will let you know I take a rather conservative view on conflict of interest, and I will talk to you about the appearance of a conflict. And so that can run all the way down to maybe you're not working for a developer, maybe you're an architect, maybe you're whoever, maybe you're the one supplying the dirt for the site. All of those things are problematic when it comes to these things. You should really have no involvement with that project. Things we've seen, if a church comes in, wants to expand, they need a variance for the steeple, or they need, expand the CUP. Things we can start to drill down into specifics. If, we've talked about if you're on the board and in a decision making, I would encourage you to conflict yourself out. If you're strictly a parishioner, probably don't have a conflict, but again, I would suggest you at least think about it, and if nothing else, disclose it. So things like that we should talk about. Questions on conflict? Okay. Gift law. Welcome to public service. You don't get any more gifts. The idea here is this doesn't mean you don't get birthday presents, you don't get holiday gifts, that's fine. Family members and the like, all of that's still fine. But if you find yourself with a new winter coat from a developer who's coming through, or Twins tickets or Vikings tickets, hey, I'd like to take you out to the game and talk to you about my project, the answer is no. If you're at the bar and all of a sudden you're approached and, hey, I'd like to talk to you about my project, would you like a beer? The answer is no, unless you're buying it yourself. The idea is they cannot buy the influence, and I would again encourage you to strictly follow this. People do get into problems with, let me pick up your dinner, thanks, nice talking to you, let me buy a beer. It's a nice social gesture, but in your current capacity, it causes problems. That's the gift law. Questions on that?
Question on that. This is hypothetical, but, let's say that you have a good friend who's a developer and they're not doing development in your community at the time.
Yep.
But let's say they take you out to a Vikings game.
Yep.
Then 6 months later, their organization is going to do a development in your area.
You have a
Should
problem.
you repay them for the tickets, or is there, is it far enough away that it can't be interpreted? Because, it seems like someone could look and say, well, we saw so-and-so out with John Doe Company at a Vikings game, so how do we know that they aren't being swayed?
Well, I think at a minimum you should repay it, but candidly, my preference is you never took the gift to begin with. And I get it, they're a friend and they're a developer, but you sit here on a planning commission and you're friends with a developer who develops in this area, you should think about that, because a smart developer lays their seeds long before they go to,
Right.
harvest it. And that's exactly what that game looks like. So I would caution against that. What the law says is you can't take a gift from an interested person. So if I strictly had to defend you, what I'd say is, well, they weren't an interested person. They had no pending project. How would we know? We didn't talk about that. We're talking about the Vikings, as I got my free game and free beers and a nice sweater. I think it becomes a harder argument if they're back here in 6 months. If they're here in 10 years, it's not as connected. 6 months, a year, We all know how long it takes to plan these projects, and they know who sits up here.
So the safer bet then would be to disclose it, pay the tickets back, and then abstain from voting on anything that they were doing.
It's the cleanest wash on that,
Yeah.
if you choose to take it in the first place.
Unfortunately, I don't know any developers. I was just kind of thinking about, what
Yeah.
kind
Well,
of potholes you could
Yeah,
stumble
well,
into.
and candidly, even in your capacity at MnDOT, if you know developers and things like that, I mean, if a local GC decides to take you out to a Vikings game, and they're also bidding on MnDOT contracts, even if you don't have a sphere of influence on that, that could become problematic.
Yeah, we have a hard, fast law about, a rule about the dollar amount that you can accept, which is like $5.
That's right.
Which doesn't cover very much these days.
No, well, it's not even gonna get you a beer, right? It might get you the plastic
I think
cup.
it might get you
Almost.
one if you drink it down here in North St.
Well,
Paul.
yes, yeah,
Just about over.
I was at the
Newman's.
stadium, yeah. No, it is problematic, and you'll hear people talk about the de minimis rule, things of that nature. Again, I go back to the credibility of government. If you're sitting somewhere and they see you exchange, and they see you having a beer, and they see someone swiping the card, I mean, there is, if nothing else, an appearance of that vote has just been bought.
And like I said, I know with MnDOT, we've got lots of rules in place. It's like, I won't even review anything for North St. Paul. I sent you that one email that one time about needing more information, but I won't touch a North St. Paul review. That goes to another planner. So,
Items not in your packet are our Open Meeting Law and Data Practice Act. You are subject to the open meeting law. What the open meeting law says is, in a forum like this, when you're making decisions, it needs to be open to the public. Staff takes care of the notices that are required, things of that nature. You don't need to worry about that. The public has an absolute right to attend. That does not mean they have a right to participate. You can choose to involve them outside of public hearings if you want, but you are not required to. You can set reasonable parameters on public hearings or other participation. You'll notice that, an example, at City Council, they do 3 minutes for public comment. I've seen it on public hearings where we introduce an item, say, look, I noticed there's a bunch of people here. What we're going to do, we're going to limit comments to 5 minutes, 3 minutes, things of that nature, and you run the meeting. You do get to do those things. Open meeting law also means that outside of this forum, you shouldn't be making decisions. Don't sit and email each other about, hey, have you read the packet yet? What are you thinking? Here's where I'm at. That's a violation of the open meeting law. You should read your packets, review your materials, get prepared. Questions should go to Brandy, but emailing amongst yourselves cannot be done. That's a meeting, even though you're not together, outside of this meeting. It's what's called either a serial meeting, or the reply all button is one of the most dangerous things out there. When Brandy or whoever sends you your materials and you reply all, this looks great, got some questions, that's the initiation of a discussion, and that can't happen. That applies both to emails, texts, phone calls. So if you call, and then you call each other, and then you call, once you've done that, you are communicating amongst a forum, and you're transmitting business. That's a violation of the open meeting law. Don't do it.
But it only relates to doing business as associated with our
Absolutely.
subject matter in the meeting.
Hey, how's your kid?
Yeah.
Great.
We can, yeah.
Yes, yep, yep. See you on Saturday at the game, whatever. It's only about business. And so, for example, if all 4 of you show up at a high school basketball game, there's no problem with that. But don't turn it into an opportunity to talk about the next meeting. So chance social gatherings, trainings, or just discussions about non-city business, there is no problem. Keeping in mind, and maybe not at the planning commission level so much, but at the city council level, I do caution against a quorum getting together. It has an appearance to it again. But as long as you're not conducting business, you're fine.
okay, so, and that is not a limitation by the number of people, right? Because I was in Texas previously, and you only ran afoul of the open meeting law down there if you had more than 50% of the people discussing a topic. If you had less than that, then they didn't consider that to be. But that was in the
No,
state law.
here it is still a quorum. So if it's just one-on-one and only the 2 of you sit and talk to each other, you're technically okay. And that happens, and I know it does. My concern is, well, after the two of you get done talking, do you go and say, hey, just talk to so-and-so, here's where he's at, what do you think? It may not initially be a violation of the open meeting law, but it can morph into one. So I'd caution against that. Final thing is you are subject to the Data Practice Act. What the Data Practice Act says is any and all city business is presumed public data. So when Brandy sends you an email, that data is public. Do you guys have city accounts for emails? No.
No.
It's something I wish we did do. If you are commingling work emails or personal emails with city emails, keep in mind that the Data Practice Act doesn't care what device you are using, personal, work, or otherwise. There is no sort of, well, I sent that email on my personal device. Doesn't matter. The content of the email is what governs its status. So if you're using your personal or work laptop to send off planning commission related emails, that is public data. And you do not get to decide the status of that data. So I've seen people say, hey, Joe, this is personal and confidential, thinking about the meeting tonight, kind of worried about the vote. The personal confidential means nothing. It is legally irrelevant. You do not get to decide the status of that email. So as you are communicating, regardless of the device, and that includes texts, that is subject to the Data Practice Act. So if someone says, you know what, I want to see what the chair sent out for emails on item A on the agenda, they get it. And so I would encourage you not only to, that goes back to the prejudging things, they can develop their own record and use your words against you, but it also goes to the, how do you choose to express yourself in those emails? Both from a, just appropriateness of verbiage to other things.
Now, is that by email address? So say we go out and set up a separate Gmail account and give that to the city and say that this is only going to be used for council business?
I would encourage that. That makes life simpler for you. But if you do that, but then persist on using your MnDOT email for city business, those emails are just as subject to the Data Practice Act.
Right, but it would be reliant more on the email address as opposed to the device then?
Yes, no, that's exactly it.
Okay.
I guess the point I was trying to make is sometimes I get the comment, well, Soren, I don't have to give you those emails, that was my personal computer. And my answer is that's irrelevant. What do those emails say? Well, this is my personal phone, these text messages don't matter. Well, what do the texts say? It does not matter what device you use. Questions on the Data Practice Act? That's usually a sad thing to learn for some folks. And where I run into some problems with that is people who work for institutions that have certain security protocols, things of that nature, banks or other things. When they learn that if you've been using your work computer and sending things throughout and we get into litigation, your computer and all of your other protocols go out the window. The other side is going to get to review some of that. So I would encourage you to think about what devices you use and what emails you use. Again, it's not going to be your work computer, so to speak, but whatever email account you are using, regardless because if that is a work email, they're going to get in there and look around a little bit. Questions? The one good news on that is you do not have to create data. So for example, if there's a request, I want copies of all phone conversations between so-and-so. We don't have to somehow say, well, what did you say during that conversation? Can you recount it? Can you write it down for us? We don't have to create data. But if the data exists, we do have to produce it. Now, that is also not an invitation to start deleting all of your emails. You are expected to retain them for a certain time. And Jenny has a retention schedule if you get curious about that. But I would just encourage you to get disciplined, use a single email account for your planning business, and then they're just stored. And if you ever get asked, well, here's access to my account, take what you need.
Is there a reason why city doesn't set up emails for the,
I don't know.
And just a question.
It was
Talked about it many times.
Yeah, it's been talked about many times. I mean, I've been on commission since 2007. It was talked about early on and several times ever since, and it never seems to,
Just doesn't happen.
just doesn't get executed for whatever reason.
It may be worth something, talking to Brian, or Brandy maybe can carry that message. I don't know how hard it is to set up email accounts. I'm hands down the least tech savvy guy in this room, sight unseen.
No, I'd argue with that.
Well, it certainly isn't
I still dictate letters.
Work in tech, and it depends upon what application they're using
Yeah,
and what cost.
right. And I just don't know the answer to that.
The last time we talked about it, it was all based on the fact that we're using the internet services that's shared with Roseville or something like that.
Yeah,
And so it was a discussion that somebody at the city had to have with them
no,
to allow us to have email addresses, and that it just never happened, so,
bogged down.
yeah.
I'll ask the question again.
And it seems like it's easy enough to set up a Gmail account that just says, you know,
Could do that.
Cameron North St. Paul Business at Gmail or something.
It's something to think about. We are at almost 8. Questions on the materials? If you do have things after you go through it and say, I wish I'd have thought of that, I would encourage you to send those to Brandy. Brandy can email me and we'll decide how to respond. Sometimes things come up. I don't typically attend your planning or any planning commission meetings. I am in contact with Brandy if legal items or issues come up. Sometimes I'll give her an opinion and she can pass that on to you, or I work my thoughts into a planning report, but I don't tend to be at your meetings. And the primary reason is you're an advisory body. Once we take your advice, we'll work that up for a final product to the council.
I had one question about the conflicts of interest that I hadn't really thought about it other than the way you started phrasing things, but the JB Vang, who's potentially developing the site across the street, my wife's an architect as well. She works with actually the person that even presented. She's the architect for them on a different project. So it's not really, they're not, I guess in a way they're paying her firm
Right.
some money. Is that
I think
taking
there's
it?
enough, I mean, that starts to get close.
Yeah.
I mean, that's, if she came in on the project,
Right,
I'd encourage you to.
sure.
I mean, the company, is she a shareholder in the firm?
No,
I mean, one of the examples we give is if Walmart comes to town, if you're upper level management or something like that at Walmart, well, then you should recuse yourself. If you're a cashier, it's not the same.
right,
So part of that, it would be the analysis with your wife.
okay,
But that is something to examine.
yeah,
Because by all means, I mean, you can start to play that out. If they get that work and it's a big job and now bonuses are bigger, does that impact where you land on something?
I have an example of a conflict of interest that I encountered because when I was on the Design and Historic Review Commission, which no longer is in existence, the city, this was a really interesting one because the city was executing a project that I, as an architect and my firm, was designing.
Yep.
And that project went to the DHRC. So I recused myself from that.
I was just gonna say, I hope you're.
For obvious reasons. But it was a good example.
Good call.
And it was a really strange one because it was a city project
Yeah.
being reviewed by a city commission. And so you get this
Yeah.
weird sort of revolving thing going on there.
It's a little different. I mean, you're reviewing your own work as opposed, yeah, I get that. I would have recused myself.
Yeah,
Yeah.
makes sense.
Yep.
Well, I'm really appreciative of you putting this together. Question though, as you've been around North St. Paul for a while, has there been any areas that you see that we might be, that we haven't covered that we should pay attention to?
Well, what I would say is, at a high level, I've talked to Brandy about my hope that you start to update your codes, which you'll see those revisions. I think your subdivision code in particular. In terms of things that you haven't covered, one of the things when I look at North St. Paul, so for example, I represent St. Louis Park, and they're fully built out. And if you've driven on 394 and gone through West End, you're gonna see a lot of cranes swinging. Now, it's a different community, but you guys, in my opinion, have opportunities for redevelopment. And candidly, I would call the Lilly building a redevelopment. I would call the Max building a redevelopment. And depending on your view on things, redevelopment's hard. We like it, it revitalizes things, but strict zoning doesn't always allow for it, especially when you start talking about density. If you're just tearing down a home, building another home, well, that's easy. But if you're tearing down an old newspaper building and building a residential unit with maybe some first floor commercial, I have seen other communities use a more vigorous PUD process where you get out of the variance business and you do some give and take within there, and it's allowed. You do have PUDs here. It may be worth cleaning some of that up, but no, I think in general, I haven't seen any reoccurring problems. And so what I've seen is, oh, yeah, I get that, why that's in front of us. This is a weird shaped lot. That's why they're here for a variance. I haven't seen any reoccurring problems.
I have one question that's not necessarily related to this, but it is related to previous things that we've talked about.
Yeah.
And if you can't talk about it or don't want to get into it, that's fine. But it's just something that's always, I think about a lot in some of the things that we review. We've had a couple times where residents have come to talk about the Shifsky's property.
Yep.
And from my point of view, it seems like it's this, fog that is surrounding that property in terms of, it's been there forever, obviously. So it doesn't, rules that were written after it, obviously it's, and I just was wondering if you could just give a quick, for us, because things will probably come up again, is my guess, how to handle things like that where it's not necessarily, it's non-conforming, but.
So that is it. I mean, you're right in terms of if you had a blank slate, is that the use you'd put right there? Probably not. Now, with that said, you have to step back for a moment and say, if I saw a big pile of dirt with a lot of trucks rolling in, would I build a gas station next to it? Apparently the answer is yes. Would I build a bunch of residential homes within 2 blocks of it? Apparently yes. In terms of what do you, quote, do with them, to the extent they are a lawful nonconformity, you manage it the best you can. By traditional planning standards, does it seem to be inconsistent? I understand that statement, but they have been there.
Yep.
They have tremendous access to the 36. They're on the east side of town. We know to build things, we need the exact thing that they sell. So what is there to do about it? From a planning and zoning perspective, not a lot. Because again, they've been there. They're a lawful nonconformity as far as we can tell. I haven't ever had to do a deep dive on it, but that's what it appears to be. Things can become, quote, a nuisance.
I think that's more where I was going, just because
Yeah.
we've had, at least twice since I've been here, people come in and want to talk about, the dust on their porch and all that sort of stuff, so.
Yep, and I understand that discussion. Nuisance to me, once you get into the realm of is something a nuisance or not, becomes a very hard discussion. I don't live next to such a structure, and I have to wash my house windows every spring because there's dust. Do I suspect some dust leaves that site? Yep, I do. Does that constitute a nuisance such that you're going to be able to shut it down or impose other things? Hard to say. The traffic that goes in and out, is it consistent with the residential traffic? No, there's a lot of big trucks. But that's what goes to sites like that. So there's not a good, ready-made solution on that. It's been there for a long time. They've operated as such for a long time. It's a service that people use and need. And candidly, as an existing business that is thriving, try and do anything with them, you know, you better make sure you're in the right on that, because that's going to be a fight.
Yeah, and I mean, just to clarify, that wasn't the angle of my question. When people come to the planning commission and, you know, they're looking for something, and I know we typically have said, well, there are these, you know, very specific things we can look at. You know, are they following these noise and, you know, all that stuff. But, yeah, I guess that was my question is that's really all we can say.
It is. What is hard is that when things were approved, like Shifsky's, I mean, a lot of cities have things like that. And you are granted a CUP, and it's not uncommon to look at those and find that there were no conditions.
Right. Yeah.
I want to operate an operation like that. Okay, yes. And then they operate. So there aren't even necessarily conditions you can fall back on for a lot of that stuff.
Okay.
It's difficult also, some of those comments had to do, while I respect them greatly, some of them have to do with people that have recently moved into the residences close by.
Yep.
And I think you moved there. You know, you knew what the operation was. So it's really difficult to address those kinds of conditions. And I think I've only found one thing, maybe two, that, shall we say, are questionable relative to the agreements on what their operation would be. So, I mean, there might still be things to talk about with the landowner, but that, I think, can be done carefully.
Yeah, well, and that's well put, and that's exactly how it should be approached.
Yeah.
They're a community partner.
Right.
Okay, thank you.
That is all I have for you. If there are other questions or comments.
I do have one, and that is, Brandy, we're down 3 members right now?
Not as
We're-
of the
we're
next council meeting.
Okay, we'll be down 2.
We'll be down 2.
But we've got a 3rd member missing, so I'm just wondering, you know, can we try to schedule another update from you in 2 or 3 months' time, so that the people that weren't here today and the new members that are joining us can be brought up to speed on this?
I think that the recording of tonight's meeting will probably be adequate for those purposes.
I'm just thinking maybe this should be something scheduled annually or every 2 years or something like that to, you know, bring us
Yeah.
up to.
One of the things I would say is I always look for turnover, or sometimes after you've received this, sometimes we come back and maybe it's helpful to run through examples and actually do some of the work, or, you know, a debrief, if you will, after a hard application to kind of go, okay, here, I've listened to where you guys' head was at. This made sense to me, this made sense to me, talk to me about this. Sometimes that's useful, sometimes it's like back off too soon. We can go over that. What I would say is I think the legislative session is going to be changing some things. And so even if the Planning Commission is identical a year from now, we may have some law changes to go over, because I do think there's going to be some drastic changes. And I think by all accounts, it's looking like it's going to become effective August 1st. So I may be back sooner than you'd think.
Great. Well, thank you, Soren. This was really good.
Good.
It's always,
Appreciate it.
it's a
Thank
good
you.
rundown to get.
Yes.
Thank you.
Oh. Thank you,
But-
Soren. We do not have anything on our old business. Are there reports from staff?
The only thing that I have to report is that the city council approved the Polar Plaza site plan last time they met, a couple weeks ago. And for next month's planning commission meeting, I think that Chris and I will start to try to look into what the old zoning map or the current zoning map looks like and kind of dig into the files and see if there's requirements or need for updating it. And then beyond that, I would probably anticipate some discussion of either the zoning or the subdivision ordinance. But no applications for the next month, or at least not. None have been received yet.
None yet. Okay. Is Jason still on? If so, does he have anything to report? Ooh,
Just what Brandy said, we, with your, traffic study recommendation, we approved the Duncan building.
excellent. Okay. How about reports from commissioners? Andrew?
I have nothing for tonight.
And I will welcome Jim officially at our next meeting.
Yes, sir.
Could you just give us a little of your background and?
Sure. So I've lived in North St. Paul now, let's see here, it'll be 4 years this coming May. Got a wife and 3 daughters. I have spent the last 20-plus years in technology as a program manager and project manager. Before that, I worked in the HVAC trades, both in residential, commercial, industrial, power plants, refineries, doing project management and overseeing large overhauls. So there's a very diverse background. How's that?
It's good. Yeah,
Give you
excellent.
Maybe a little bit of context.
Yes, yeah.
And so my purpose, as I shared with, those that I interviewed with earlier, was, the reasons for me being a part of Planning Commission is being able to give back to the community. And looking at all the different commissions that were there, I felt this is the one where I can contribute the greatest. And, because I do understand some of, how communities, how things are put together and what makes a good community.
Awesome. Well, welcome.
It'd be great to have you on board when we start digging into that subdivision ordinance.
Yeah, well, and I've lived in 1, 2, Iowa, Wisconsin, Illinois, Michigan, Minnesota, 5 different states, all upper Midwest, so, yeah.
Good deal. I appreciate that. Thanks, Jim.
You're welcome.
Cameron, anything for you?
I guess, Brandy, I just want to go on record that I will not be here for the June meeting. So,
Thank you. We'll make note of that.
okay. Yeah, I will be one day out of Southampton on the Queen Mary at that point. So I think it will be very difficult for me to make it.
I wonder what date that is.
I don't know, but
Do you happen to know? Do you have your calendar handy?
June 1st.
Oh, good, I'll be here. I thought I was going to be here for that. I'm now on that. If there's a meeting on my calendar, I'm not planning anything to happen as best I can, so. I don't have anything further. That being the case, we have gotten through our agenda. Do we have a motion to adjourn?
I'll move.
I'll
Moved by
second.
Muick. Seconded by Weiss. All in favor?
Aye.
None opposed.
I guess I can't oppose my own motion.
Nope. So,